You are listening to Heavily Accented Philosophy of Law, a podcast powered by the HAPL Project. Welcome to this new episode of the Heavily Accented Philosophy of Law podcast, powered by the HAPL Project. Here am I, Julieta Rabanos, and then also Bojan Spaić.
Finally in Belgrade, and finally being able to use the equipment that we have in Belgrade to record the podcast. A bit sorry that our guest today isn't also in Belgrade, so we could hang and speak in this room, but this is the best we could do at this point in time.
It would be extremely good to have our guest today, Mathieu Carpentier. I'm so sorry for the pronunciation. I always butcher the pronunciation in French. Welcome, Mathieu.
Well, thank you, Julieta. Thank you, Bojan. Your pronunciation is perfect. Much better than my Spanish or Serbian pronunciation, for that matter.
Everybody has problems with Serbian pronunciations for some reason.
For some reason, look like here you have like 5 consonants together. Like, try to pronounce this.
Yeah, Julieta had this problem, Mathieu. She always catches these words which are really weird. So I started
like
proceeding.
Srpski.
Yeah, like Srpski, like trg, like trg, which are very.
Which means square, by the way.
Yeah.
So okay, like again, heavily accented philosophy of law live. For the listeners. So maybe we can start this episode with the same question that we started the other episodes with. So how about you tell us a little about your academic path to the present?
Yeah. Well, first of all, I'm really chuffed. I'm honored to be part of this wonderful series. It's really a great podcast. And really, whenever I do chores, that's one of the 2 or 3 podcasts I always have in my ears that make the chores much easier to do. So I am French. I grew up in Paris and went to university in Paris. I studied first philosophy, then law, and then I went on to make a PhD in Paris at the University of Paris 1, Panthéon-Sorbonne. A PhD in legal philosophy devoted to the notion of defeasibility in law. Then afterwards, I kind of pivoted to law more generally, and I became first an assistant professor in public law at the University of Paris 2. Yes, universities are numbered in Paris. Panthéon-Assas, where I stayed for 2 years before getting a full professorship, still in public law, at the University of Toulouse, University of Toulouse Capitole, to be more exact. And this is the university I'm still a member of today. So the bulk of my work is mainly in legal philosophy and legal theory, but I also work more and more about, bread and butter public law issues, and I'm trying to bridge also the gap between legal philosophy and, public law doctrinal stuff by trying to find ways to make those 2 fields have a dialogue of sorts. So, yeah, that's it, I think.
You are our second guest that had defeasibility as one of his main topics for his PhD.
Oh, yeah.
Our last guest was Pedro Moniz Lopez, and he was talking with us a bit about defeasibility. He also moved as time passed from the topic, and he's now doing equality, classification analogy. But yeah, it is interesting that we have 2 guests, one after the other, who did defeasibility. Did you stumble across Pedro's work while you were doing your thing?
Well, not while I was doing my PhD, because I finished it a bit earlier than than Pedro, and well, I wasn't very well aware of the booming Portuguese scene in legal theory. I had heard, I mean, my main Portuguese reference was David Duarte, of course. I cite many of his articles in my PhD, but Pedro, I was not aware of his work, and we met like 3 years afterwards, after I defended my PhD, and he just told me, "Look, that's very funny because I mean, I just defended a year or so ago my PhD on this very topic, and that was the beginning of a wonderful friendship, as they say in California."
Yeah.
And also, it's funny how from very different path we got to the same object without even knowing the existence of each other.
Absolutely. We were talking with Pedro the last time about the formation, and there are some details that I didn't know about the formation of Lisbon Legal Theory Group, or as it is now called, just Lisbon Legal Theory. They dropped the group part, and we figured that they were actually formed maybe a year or so before we met, and our first major meeting was in Washington on the IVR. So it would be interesting to me to, and we were talking a bit about legal theory in Portugal, legal theory in Lisbon. It would probably be interesting to our listeners to hear a bit about legal theory and philosophy of law in France, or at least your assessment on your faculty, as well as if you can muster also France in general.
Yeah. Well, my assessment is going to be a bit severe. I mean, it's my subjective opinion, of course, and nothing I say should be construed as impugning the overall competency of my colleagues. But there is two trends in France. The first trend is first, there is this kind of distinction that is made that is quite under-theorized or incompletely theorized between legal theory, that is done by lawyers, and legal philosophy, which is done by philosophers. And the first trend is to say, no, we're just doing legal theory. It's an autonomous discipline. And what philosophers have to say, well, we don't care much about that because they work mainly on, normative issues like justice and stuff. And we're not interested in that. And what I'm trying to tell to this group of people, whom I love and who are some of my closest colleagues and friends, is, well, you are doing legal philosophy. I mean, these kinds of neat categories do not work when you try to just take a look at what is done outside France. I mean, would you say that Hart is a legal theorist or a legal philosopher, that Raz or Dworkin are legal theorists? It doesn't make sense. But those guys are doing great legal theory or great legal philosophy, even if they refuse to use this term. They are basically associated with the Nanterre school, which was initiated by Michel Tropper in the 70s. And well, they are great. Really, they're doing great work, but there's still this idea that, well, we're not talking much with philosophers. And on the other side, which is much more diffuse, much less, institutionalized, so to say, you have many people who just like to, how could I say that politely, to divagate about law. Usually lawyers, usually professors of law, or sometimes professors of philosophy too, but it's more common on the law side because philosophers do not care much about law or legal philosophy in France, with several exceptions, my PhD advisor included. But usually you have like the typical cliche, you have a 50-year-old private law professor who had his whole career devoted to banking law,
so related.
or commercial law, and did a lot of money on the side thanks to this gig. And then at 50 he has his midlife crisis. I say he because it's usually he, and decides to write a treatise on philosophy of law, right? Which, of course, cites Aristotle, Aquinas, sometimes, just when we're lucky, the second scholastic, a bit of Hobbes, a bit of Kelsen, and that's it. And Kelsen widely misunderstood, by the way, but that is more common than just the French case. And then, well, of course, they have not read anything that's been written in the 20th century, for instance, or only very obscure and idiosyncratic thinkers that nobody outside of France knows, basically. And of course, this is very scattered, this is very fragmented, and but it is kind of a worrying trend. So in terms of institutionalization of legal philosophy, you have either old law profs that do, poetry, let's put it that way, and you have some very dynamic schools like the Nanterre one that are a bit closed onto themselves. Well, they kind of accepted as a travel companion people from the outside, myself included, but you don't have kind of a strong forum of doing like general jurisprudence across universities. We've been trying to instigate something like that with the French section of the IVR, of which I'm a board member, but it's still something that is still embryonic. You have very bright young researchers. I say young up to 40 in order to convince myself I'm still young, which is delusional, of course. But you've got like young legal philosophers. I'm thinking about, for instance, my friend, colleague Gregory Bly, for instance, who works on Hart and who is maybe the main French person working on Hart today. But they are scattered across different universities, and well, they have regular contact with each other, but they're still not kind of an institution that would structure the field in France. So it's still fragmented. Lots of individual people doing wonderful stuff. Some schools that are kind of a bit kind of self-centered or close onto themselves, and lots of scattered work of poor quality. So that would be my assessment overall, and that explains why legal philosophy in France is not, it's not mainstream. For instance, in my university, there is no undergraduate class, no undergraduate course in legal philosophy or legal theory, whatever you call it. And in many universities, it's the same, or if there is such a course, it's optional, and it's not done by someone who's very knowledgeable in the discipline, et cetera, in the field, And that explains why, for instance, at the IVR Congress, the French delegation is not as big as it could be, et cetera, and why France isn't very much on the map in terms of international legal philosophy as such.
Unfortunately, most of the things that you did a fantastic job of explaining are quite relatable. So we have these situations that are kind of similar to the French situation, at least partially in some cities in Serbia. I don't know about the situation in Argentina. Julieta knows it better, but I certainly hope that the things will consolidate in philosophy of law, because I think it would contribute significantly to the debates on various topics of nowadays in philosophy of law. Before we pass to these bread and butter questions and issues and the substantial things, I want to get a scoop out of you. Do you have any idea where the IVR will be held in 2028? Maybe any ideas?
I can't. This is still very much secret, and now I feel like I'm giving you a scoop, or like I'm deep throat in all the President's Men. So basically, we don't know yet exactly. because to be so I'm part of the small group that is trying to organize this Congress in Paris. So it's going to take place in Paris. That is 100% sure. There is no qualms about that. The question is that you don't have in Paris like a big university building with a big amphitheater that could accommodate like 800, 1,000 people and 60 rooms for the workshops. We don't have that. For instance, at the Sorbonne, if you want, I'm talking downtown Paris, central historic Paris, the Paris that, touristic people kind of like. So basically, you've got the Sorbonne, but the Sorbonne, you have one very big amphitheater that is used only for, ceremonial stuff, and that you need to book years in advance, and booking it for like 5 days in a row won't be possible. And even in the Sorbonne, you couldn't have, and it's a maze, it's impossible, it's a very old building, blah, 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 and you couldn't find like 60 rooms sufficiently adjacent in order to have people move from one workshop to another. So it's a nightmare. So basically, we're exploring other possible venues. We will probably have for instance, the inaugural ceremony, or the opening ceremony in the Sorbonne at the Grand Amphithéâtre de la Sorbonne, this big ceremonial amphitheater. The rest of the Congress, it's more complex. We will maybe work around the edges to some extent by modifying some parts of the organization of the Congress. We won't have, for instance, all the time the keynote lectures, the plenary lectures in the morning, and the workshops in the afternoon. Maybe they're all days without plenary lectures, and only workshops. We don't know yet exactly how we're going to proceed, but it is very well possible that it's going to be on the outskirts of Paris. Basically, we have the possibility of having what is called the Condorcet campus, which is a newish campus, new campus. It's like 5 years old in Aubervilliers, which is directly accessible via subway, and which could offer the kind of amenities we would like to have. And I didn't mention like air conditioning. You all remember Bucharest, right? Mm-hmm. So Sorbonne, of course, no air conditioning in the Sorbonne, of course. So if you want to, so we can't do that in big buildings, historical buildings in downtown Paris. That's impossible. And another prospect we have is making at least part of the Congress at Nanterre, which has this it's a new campus, new, it's from the 70s, so it has kind of big theaters and lots of workshop rooms. So it's going to be a bit kind of a bricolage, because we're not like Frankfurt or Georgetown or the University of Lisbon, or I'm thinking or even the university where in Seoul. We don't have this kind of big downtown campus that could be useful. So we're going to work with what we have and keep the community updated as soon as we can.
Okay, you heard it first here in this podcast about this spoiler in regards to IVR 2028. Okay, so moving a little towards the substantive part of this episode, which should be related to legal validity in a wide sense, and then things and naturally trends that come with the research on legal validity. Maybe we can start with a very beginner's question, like what is this thing about legal validity, and what would be the classical view of legal validity, and why do you think that it's important to research on legal validity for doing philosophy and theory of law?
Well, thanks a lot. Well, what is legal validity is is quite a difficult question to answer, because precisely I'm going to try to suggest that people are actually confused about what they mean by legal validity. But if I had to choose kind of a smallest common denominator definition, I would say that a vast majority of legal philosophers would define validity as the specific mode of existence of norms. That's, for instance, the Kelsenian definition, which is not a complete definition, because, of course, Kelsen's definition of validity is much richer, but we could say that a norm is valid when it exists, and vice versa. And the existence of a norm will typically entail a series of consequences, like that it can be enforced, that it can be applied, that it is binding on the members of the community, of the legal community, etc. So legal validity is the mode of existence of legal norms. But of course, the big question here is, what does it mean for a norm to exist? Some people outright deny the very existence of norms in a meaningful sense. And others will disagree about what exactly we mean by existence. Does it mean that we have a norm that belongs to a legal system? Does that mean that people have to obey it, etc., etc.? So there's a lot of issues that are intertwined. And before coming to your second question, why it's important in legal theory, I'd like to add that there is a further complication in this definition, or rather in the consequence, in elaborating the consequences of this definition, is that you've got a lot of issues surrounding validity that are linguistically dependent, or language dependent, to put it that way. For instance, typically in German and Germanic languages, you typically have two words for validity. Like in German, when you want to say valid, you can say, or validity in German, you can say Geltung or Gültigkeit. And you've got the same thing in Nordic, or at least Scandinavian languages like Danish or Swedish. I'll come back to that a bit later. The same way in Spanish, for instance, and now, of course, Julieta, if I'm talking nonsense, you just tell me, but I'm under the impression that in Spanish, I have basically two concepts like validez and vigencia that are usually translated as validity, even if they have a different meaning, a different flavor. Of course, definitions, especially in legal theory, are stipulative. So we won't have like real definitions, definitio realis. We won't have that, but still, in ordinary legal parlance and ordinary jurisprudential talk, if such a thing exists, I would say that a German speaker or Spanish speaker would distinguish between Geltung, Gültigkeit, Validez, Vigencia, even if those two distinctions do not quite neatly map onto one another. And these linguistic contingencies entail sometimes, interpretive confusions. There is, of course, this classic case, about Alf-Ross's On Law and Justice. Ross uses two different concepts of valid law, gildig and geltend ret. My Danish pronunciation, of course, is bonkers, but I can't do better than that. And of course, since those two concepts were translated as valid in valid law in the first translation of On Law and Justice, then of course, Hart, in his famous criticism of Ross, especially in the article called Scandinavian Legal Realism, kind of missed the point of what Ross meant by validity in either senses. We can come back to the specifics a bit later, but my only point is that there is this kind of conceptual conceptual indeterminacy to some extent, and of a linguistic misunderstanding about what is validity. Because sometimes, like French, Italian, English languages have only one term to say validity, whereas other languages have two. And that, of course, informs the way legal philosophers conceptualize validity and talk about it. And why is it important for legal theory? Because some of the most important legal philosophical debates throughout history and up until today have been focusing on this notion of validity. Typically, the debate between legal positivism and non-positivism is to some extent about the criteria of validity in given legal systems. So basically, and to put it in a very, of course, simplistic terms, a legal positivist will say that the criteria of validity of legal norms, I mean, the stuff according to which legal norms are valid, that is, exist, those criteria are social facts, like legislation, precedent, custom, etc., and are social facts only. That is, if you do not have these kinds of social facts, you can't have valid norms, basically. Whereas, of course, anti-positivists of not necessarily all, but most tribes would say that no, among the criteria of validity of a legal system, what you have is moral criteria, moral facts. A norm being morally meritorious can be valid even if the social facts, usually called sources of law in a metaphoric fashion, do not obtain. And typically, the debate between positivism and many iterations of non-positivism bear on this notion of validity. And the problem, of course, is that if all those titans of jurisprudence do not talk about the same thing when they talk about validity, then there is the risk then they are talking past each other, and that actually the debate is about nothing.
I wanted to just do a follow-up in regards to what you were saying before, like, going to other question, which maybe has to do with the methodology of concept construction. But then you mentioned criteria for validity, and there is some discussion maybe in regards to validity in itself, in which it might be good to differentiate criteria for validity and the concept of validity in itself. In the sense of, for example, I am thinking maybe Hart's reconstruction about what validity is, in which it is clear that there is a distinction between criteria for validity and the concept of validity in itself. Do you think that this is something interesting or something that is important? And do you think that is something that it should be taken into consideration when trying to analyze the issue?
So if I get the question right, the question is, can we talk about validity, the concept of validity, without focusing necessarily on criteria of validity? That was the question, right? Or
yeah, more or less, in the sense of that I think that some authors, when they talk about validity, they conflate criteria and definition, if this makes any sense. And then, for example, there are some other authors, like, let's say, Hart, in which this separation is very clear. So what do you think?
Yeah. Well, if you, I'm not sure I have a complete answer to that question, because actually it's a question that I'm grapple with, I mean, every day. So basically, it's all about what function you want to give to a given concept. So basically a concept like validity is good only if it serves a useful function in legal theorizing or in whatever other area of theorizing you're talking about. So my question is, and that's where things get tricky, is that I basically don't think that the concept of validity serves any useful function as such in legal philosophy. That's why I don't think that we can find I'm not even talking about a real definition. I'm talking about a satisfactory stipulative definition that would serve everybody's purposes. And that's why I think that when we talk about criteria of validity, what we're talking about is not actually criteria of a given concept that is validity. We're talking about something else. We're talking about criteria of, for instance, membership. And then you can definitely talk about validity without focusing on, the positivism and anti-positivism debate. You can, and lots of people today are talking about validity as a self-standing category, and I don't deny that. It's possible because it serves useful purposes, useful functions. So when you hear, for instance, like Maris Kopke talking about validity today, she has a very specific concept of validity, which serves specific purposes, and she doesn't need to wade into the debates about, criteria validity in the positivistic fashion, because, well, her general outlook is, anti-positivistic. And the same goes with Dworkin, the second Dworkin, that's the Dworkin from Law's Empire, except that he dispenses with validity altogether. He doesn't care about validity altogether because he doesn't care about legal norms altogether. What he cares about is grounds of law and what makes legal propositions true. And that's great. But that shows that a concept is only good insofar as it serves good theoretical functions or purposes. And that's where I think legal validity is a tad problematic as a concept.
So to follow up on the conceptual side of things, as far as I understand, you're trying to develop legal validity, or at least you're aiming to do it by claiming and elaborating that validity and legal validity is basically a cluster concept. Now, this is an idea that has been developed in quite a few domains and has recently, in some work that I read, been used in philosophy of law. Most importantly, I think Viisa-Kurki used it to explain the concept of legal personhood in his book on, I will now just
Legal
invent it,
legal
personhood.
Yes.
Yeah, that was close to.
I think that's also Frederick Schauer in his last book.
Yeah. Interestingly enough, I came across this idea of cluster concepts by using another idea that was essentially contested concepts by Bruce Walter Galley. And in the 90s and 2000s, it was a very important idea for example, Michael Frieden, who did the book on political ideologies. He was an Oxford scholar who was doing these things. So it's very interesting to me to hear what are your ideas on cluster concepts in general, and how do you connect them with these ideas of legal validity?
Well, cluster concepts are close to what Wittgenstein calls a family resemblance, right? So it's a case of what you could call meta-ambiguity or extensional ambiguity, if that makes sense. That is that it is a concept that can be defined. I mean, its intention can be defined via various sets of properties that are partially overlapping. And if you want to give a complete definition of the concept, you can't, because you cannot tell which set of property is definitive, because no set ever is. So basically, when you use the concept of vehicle, for instance, in certain contexts, the fact that a given object has wheels and a motor and is self-propelling will be enough to have a concept of vehicle. But if you are talking about a toy car, then you've got a bit of a problem, in the sense that maybe other properties that are not relevant in the first concept become relevant in the second. So of course, cluster concepts are linked with the idea that sometimes whether the application of the concept is possible is context dependent and is mainly determined by pragmatic factors. So, and I think that explaining cluster concepts in terms of overlapping sets of properties according to context, I mean, helps understand, for instance, the Hartian notion of open texture. Basically, is these cases of meta-ambiguity. It's not that you have two different concepts expressed by the same word, or syntactic ambiguity, two different propositions expressed by the same sentence. It's rather that you have 2, 3, 4 interrelated concepts with overlapping properties that are definitive, and you cannot give a complete definition per genus et differentiam or via necessary and sufficient conditions. And I think that legal validity is a cluster concept, which explains why I think it can be and it should be broken into more elementary units of meaning, more elementary sets of properties, while still being aware that in ordinary legal parlance or in ordinary jurisprudential parlance, I mean, those more elementary units of meaning are meshed one into another. And that's normal. And here you have two different strategies. The first is to say, well, legal validity is a concept that is used daily by lawyers. You have lawyers in every jurisdiction I know of that will say that this contract is invalid, for instance, in front of a judge. And you cannot do away with that concept because, you know, it doesn't have a close set of necessary and sufficient conditions of application. But still, I still find that unsatisfactory. So that's why I choose the second strategy, not to take the concept seriously with all its clusterness, but rather to say, for theoretical purposes, it's not about conceptual ethics, it's not about conceptual design, it's not saying we're going to reform the concept of validity, because I think that doesn't make sense, especially in legal practice. But to say what we're going to do is work with more elementary units of meaning, more elementary concepts that have a more, you know, a definite outline, a more definite contour to them, which makes them easier to use, to utilize without committing category mistakes or conceptual confusions. So for me, validity is really a case in point that sometimes I mean, it's not because something is a cluster concept, and I think that it is the case that it is a cluster concept, that it necessarily has to be used as a cluster concept. What you can do is try to isolate those partially overlapping sets of properties and study them in isolation. Doesn't mean that we're going to reform the way people use this concept. Again, it's not a matter of conceptual ethics. It's not a matter of conceptual engineering, if you like. It's more saying we can avoid such and such and such confusion if, rather than talking about validity, we talk about something else.
I think that it boils down to something that you have already said, which is basically usefulness of the concepts. Yeah. But naturally, the question that follows from your reply is, what are these units of meaning that you were talking about? I think that naturally membership is one, because you were also mentioning it when you were talking about criteria versus definition, but what are these units?
Yeah. So basically, there are at least 3, 4, even 5 possible units according, and again, it's all stipulative to some extent. So first, there is membership. So membership, it's not a theory neutral concept. It's a theory laden concept. You cannot use the concept of membership without presupposing that law is made up of legal norms and not of something else. But because law could be made of something else, right? We could say that law is a bunch of people wearing robes and wearing wigs, and that sometimes pronounce judgments on the fate of other people. You could very well have that, or you could say that law is a set of books, a set of texts, and I'm caricaturing a bit, but that's kind of a mainstream approach in various iterations of realism of legal realism on the continent. So, but as soon as you accept, at least, you assume provisionally that law is made up of norms, then membership is a nice concept to work with, because then it explains how norms can come into existence. Moral philosophers have go into a lot of trouble to explain how normativity can exist. So you've got various kinds of metaethical gigantomachy here that try to locate the source of normativity, to parrot a famous book by Korsgaard. Now, if you accept this notion of membership, it's much easier to solve this riddle. Legal norms, and that is a reasoning that can be extended to other kinds of norms, but legal norms exist because they belong to legal systems. And they belong to legal systems because in legal systems you have definite modes of production of norms. Okay, but again, that supposes that we're talking about norms, that is stuff that have a deontic function. And of course, you can deny that law is made up of norms. If you are a moral realist that equates normativity with robust normativity, or with what Joseph Raz called justified normativity, well, law is going to be made up of mock-up norms, like fake norms, or what David Enoch calls formal normativity, which is no normativity at all, because it doesn't give rise to genuine reasons for action. But so there's a lot of theoretical assumptions in the concept of membership. But if you agree that these assumptions are at least prima facie sound, then you will accept that legal norms exist because they belong to a certain legal system. But when we say that a norm belongs to a legal system, we haven't said much. And again, lots of people have used validity to mean something else. So basically, although you find sometimes in Kelsen's work this notion of membership, it's not quite important. What Kelsen means by validity is bindingness. A norm is valid if what it prescribes is gesollt. Ought to be. But the Kelsenian ought, of course, encompasses all the various modalities, deontic modalities. So it can be permission, empowerment, rights, etc., etc. So basically, if you have this concept of bindingness, norms exist only if they are binding. But that gives rise to many problems. What does it mean for a norm to be binding if we believe that legal normativity is relative, which is something that, of course, Kelsen agrees with? So how can a norm be binding on me, a French citizen, and not on you? And this is this idea that a norm would be binding per se, just because it exists, gives rise to a lot of issues. And of course, Alf Ross, in his famous refutation of Kelsen, validity and the conflict between positivism and natural law, says that Kelsen is a quasi-naturalist because he presupposes an absolute concept of validity. But of course, so that is the second concept, is kind of absolute bindingness. But you have another concept, which is what Eugenio Bouligin calls relative bindingness, or norms of applicability. That is, that norms are binding insofar as judges have the obligation to apply them. And why do judges have the obligation to apply them? Is because certain norms of the system, which he calls norms of applicability, make those norms applicable. And there is often a mismatch between membership and applicability. Sometimes a norm belongs to the legal system and isn't applicable yet, because in cases of vacatio legis, I think that is well known, but it's still worth elaborating on. Just, before the law enters into force, the norm are not applicable, but are still belonging to the legal system, because normative operations can be performed onto those norms. They can be derogated, repealed, even before they enter into force. And likewise, you can have applicable norms that do not belong to the legal system, like in cases of private international law issues, where you have like a German norm that can be applicable in France without being part of the French legal system. So this is basically a third concept of validity, which is distinct from both membership and absolute applicability. Of course, this mismatch cannot be complete. It would make no sense to say that you have, on the one side, the norms that belong to the legal system but are never applicable, and on the other side, the French legal system would only apply norms from the German legal system. It's not conceptually impossible, but it's practically incoherent. And of course, usually there is a strong connection between the two. That's why, I've been arguing for kind of an impure or mixed conception of the rule of recognition that Bouligin would, of course, reject, because according to Bouligin, the rule of recognition is just the conceptual rule that sets out the criteria of membership. But it has no bearing on the applicability of norms. And I would say that, well, at least from a pragmatic point of view, you could say that the rule of recognition serves as a prima facie default norm of applicability, which can be defeated by further norms of applicability in the system. And otherwise, you cannot ascertain what the criteria of membership are, because remember that in order to ascertain in a given polity what the rule of recognition is, what the criteria of membership are, you need to pay attention to the practice of officials. And if officials do not act as if they were relatively bound by those norms that they deem legal, we couldn't be able to ascertain what the rule of recognition is in the first place. So there needs to be this kind of relative applicability by default that applies as soon as a norm belongs to the legal system, but of course there is a mismatch. So the fourth concept is the concept of efficacy. Of course, whether a norm is obeyed or applied in a grosso modo efficacious manner could be a determinant of its validity. But that's a debate per se, and I have nothing much to say about that very debate because it's been, I think the positions are well mapped out. My own idea is that efficacy is a global condition of membership. That is, that if you do not have an efficacious legal system in the first part, you do not have any reason to talk about membership of norms, but it doesn't make sense. But now, the fifth concept, which I think is the least isolated in the literature, is the concept of conformity. And we can talk about it more later, but basically what I'm saying is that whether a norm conforms to a higher ranking norm, like a contract conforms to a statute or a statute conforms to the Constitution, is a different question from whether it belongs to the legal system. Those are two different issues that are dealt with different sets of rules. So basically, I am arguing that rules of change, which determine the content of the competence of various lawmaking organs, like the Constitution or contractual norms, for instance, the statutes about contracts. Well, they are of a different kind and serve a different function than the rule of recognition. That is the claim. That's a paper I'm writing right now about the non-redundancy of the rule of recognition against people like Jeremy Waldron, for instance, who agreed that, since the rules of change tell you what you need to do in order to make law, what you need to do in order to make law is just the criteria of membership. And the problem is that unconstitutional laws, unconstitutional statutes are aplenty. You've got plenty of unconstitutional laws in lots of legal systems. And until they have been either disapplied or repealed by courts, they are perfectly valid in the sense that they belong, in the meaning one I talked about earlier, to the legal system. And in some cases, courts are not even empowered to repeal said norm, which explains that, for instance, when the US Supreme Court issued its Roe v. Wade decision in 1973, it didn't repeal the anti-abortion laws that were in the books. And as soon as the Dobbs decision in 2022, reversing Roe went into effect or was handed down, those norms that were inapplicable became applicable again, which proves that they still belonged to the legal system. So what I'm saying, and that's it, I've written a couple of papers on that, is saying that whether a norm belongs to the legal system is different from whether it conforms with the rules of change, with all the norms that restrict the competence of the norm maker. Of course, there is an overlap between the two, again. But that explains, in my mind, why a norm could belong to the legal system while being widely unconstitutional. And in cases in which you do not have a system of judicial review of legislation, like in the Netherlands, for instance, well, those norms are going to stay valid. They're going to still belong to the legal system unless and until they are repealed by the legislature. And I think that this is not only important in terms of practical relevance of concepts, in terms that now this concept can explain this concept of conformity as distinguished from the concept of membership, can better explain what is at stake when a court repeals or disapplies an unconstitutional norm. The norm existed, the norm belonged to the legal system. Otherwise, we couldn't even talk about an invalid norm. It would be a contradiction in adjecto. So it belonged to the legal system, but it is invalid, it is unlawful in the sense that it doesn't conform with a norm, that defines or restricts the competence of the norm maker. So that's what I've been pushing for, better conceptual clarity in terms of distinguishing these 4 or 5 concepts, if you include efficacy, which I do not work a lot with.
Thank you, Mathieu. There was one quick follow-up question came to my mind as you were speaking, and you'll correct me if I'm wrong. There are at least 2 instances where in some of these concepts, for example, for the concept of efficacy and for the concept of membership, you relied heavily on the concept of a legal system. And now what I wanted to ask you is to which degree do you think that your views on these 2 things as well as on legal validity hinge on a rather strong idea of the unity of a legal system? Because to my mind, this having a strong idea of the unity of a legal system might be in various ways problematic, in the sense that there might be norms that are valid within one part of the legal system and not within the other part of the legal system. There might be 2 legal systems in which 2 different norms are valid. There might be 2 conflicting norms within one and the same legal system, both norms being valid for some of the other reasons that are not reasons of membership and so on. So how much do you think that that a potential conception of a legal system influences or could influence your thinking on validity?
Well, that's a great question, and I'm not sure I have a definitive answer to that question. I do think that, of course, if you remove from the equation the notion of a legal system, well, of course, everything I've talked about and everything I've written about, falls down, and why not? Now, does that commit me to this notion of a unity of a legal system? Actually, I'm not so sure, and I've suggested that in a couple of papers too, but I think that my views are much more tolerant with legal pluralism than, than, for instance, Kelsen's view, to take an obvious example. So basically, all I'm saying is that a norm exists if and only if it belongs to a legal system. But that doesn't mean that a given person can be the subject of cannot be the subject of 2 different legal systems. They can. Or that a single territory could be part of the sphere of territorial validity of only one legal system. I don't think that. You've got case, for instance, all kinds of federal states. The citizen of Arizona is both subject to the laws of the Arizonian legal system and to the French legal system. And you could say that, for instance, some laws in France of the French legal system do not apply to, Alsace, for instance, due to historical reasons, or to some of our overseas territories. But then it's okay. We can either say that some norms they belong to one legal system and they are not applicable in some parts of the system due to territorial norms of applicability or personal norms of applicability, or we could even say that there is no such thing as the French legal system. And that what you have actually is kind of a federal system. You have the French legal system, and within the French legal system, a subsystem like the Arizona legal system. And since my view of normative conflicts is that normative conflicts are perfectly possible within a given legal system, I am perfectly comfortable with the idea that normative conflicts could apply across legal systems. That is, of course, something that, I mean, that is one of the big reproaches that Hart addresses to Kelsen, that he is incapable to understand normative conflicts across legal systems, like across the international legal system and the municipal legal system, or even across normative systems of different origins, like the moral system and the legal system. And I'm totally siding with Hart here. All I need is that a norm exists because it belongs to the legal system. But that doesn't mean that there is only one legal system that is operational on a given territory or a given set of addressees.
I would say I have two follow-ups in regards to this extremely interesting 5 units of meaning that are surrounding or in some sense under this umbrella thing of validity. The first question would be, when you talked about efficacy, you talked about the efficacy of the system. Well, naturally, my follow-ups would be why efficacy of the system and not efficacy of the norm, which is basically because in the other elements, it seems like the norm, whatever this is like the object of the thing. The other thing is that if we don't have a legal system in itself, because we were discussing the possibility of not how this efficacy applies. And the second, that maybe it hinges with the first, is that I feel that your elements are not at the same level, in the sense of I think, or I perceived when you were explaining the 5 of them, that maybe they are not all of them independent from each other. It seems that there are some that hinge upon at least one of the others, so they seem not at the same level. Do you think that there is this conceptual connection between some of the elements, or that all of them are at the same level, let's say, of analysis, or in whichever idea we can draw from this?
So, great questions. Regarding efficacy, of course, you're completely right. We could talk about the efficacy of the norm, but I would say that an intuitive response, and that is what broadly Kelsen says, I mean, maybe in a less simplistic words, is that, well, you can talk about the efficacy of a given norm, but usually a lawyer will not describe an inefficacious norm or ineffective norm as being invalid in either of the other senses I've talked about, unless there is some kind of desuetudo doctrine that is, applicable. So a Hartian would say that, well, sometimes desuetude is among the criteria of invalidity, of non-membership that exists that are picked out by the rule recognition. Sometimes they don't. So sometimes, you can still apply, or you can still say that belongs to the legal system, and therefore prima facie is applicable, a norm that was enacted in the 1800s, for instance. So, of course, and the problem is that when we talk about desuetudo in the legal systems I know of, things are not clear at all, actually. Sometimes judges will invoke desuetude in order to justify just, disapplying a given norm. I don't think there's a kind of stabilized practice that would make desuetude part of the the standard criteria of membership that you find, or non-membership that you find in the recognition, like legislation, precedent, custom, etc. That's the first point. So that's why it makes more sense to ask about efficacy as not a part of the concept of validity, but as a condition of validity, but as a conceptual condition, not as a legal condition, but as a conceptual condition, that it makes sense of using the concept of validity as a norm oriented level, if only you have a legal system to begin with. And for that, you need to have, some kind of global efficacy. And that's something that both Hart and Kelsen, I think, agree on. Because if I'm, I'm in a madhouse or a psychiatric asylum, and I dream that I am Napoleon, and I'm enacting statutes, and I'm enacting a constitution, etc., etc. And that's great. But of course, it's not an efficacious legal system. And so it doesn't make sense to even ask whether there are norms to begin with that could belong or not belong to it. That's the first question. So the second question, they are definitely not independent. For instance, of course, let's say that you have the norms that the rules of change that define the procedure that the legislature must follow in order to pass laws. So, of course, if the legislature breaks those rules of change, it doesn't follow some procedural requirement, or even it doesn't respect some substantive requirements, like respecting fundamental rights, for instance, well, it will have violated the relevant rules of change, and it will be invalid. Now, some of the facts that make this invalid in the sense of unlawful or non-conform are also parts of the fact that make laws belong to the legal system. So, for instance, if you take the French rule of recognition, you would say that a norm passed by both houses of parliament and promulgated by the president of the Republic is law, is a legal norm, belongs to the legal system. So obviously, if you have the president of the Republic who decides to promulgate a norm that has been passed or even read only in one house, that's going to be a problem. And people are not only venture whether, they're not going to be asking whether the norm is ultra vires or not. They're going to ask whether we have a norm at all, a legal norm that exists or not. But still, what I'm saying is that those two concepts can be conceptually distinguished, even if they are in practice overlapping, because asking whether a norm which exists is ultra vires or not is not asking whether a norm exists or not, because when you talk about the norm of the fictitious Napoleon in his madhouse, you're not asking whether it is within the competence of Napoleon, scare quotes. So, of course, they are not completely independent, but this is just, the consequence that they are usually used together, meshed with each other in this cluster concept that is legal validity. The fact that legal validity is a cluster concept means that there is this kind of partial overlap. And otherwise, of course, it would be a case of pure ambiguity, of, homophony. You would talk about, like you would talk about a bat, talking about, a baseball bat or a nocturnal animal. But that's not the case. Of course, if we're talking about a cluster concept, another case of ambiguity, it's because there is this kind of overlap. But that doesn't mean that we cannot study those concepts, those more elementary units of meaning, in relative independence from one another. Even if, of course, in practice, it's quite more complicated.
Yeah, I'll follow with a couple of questions that might be related. Now, this cluster concept view of legal validity is, to my mind, something that has some bearing and might have some important bearing on two things. Basically, the first one is the definition, the very idea of the rule of recognition, the Hartian idea that has been following us for 60 years now. And the second could be the possibility of your views being relevant for a debate that has been following us for 50 years or 55 years between inclusive and exclusive legal positivism. Could you frame that a bit for us? How do you think it changes, influences, falls into these debates as well as views on the rule of recognition?
Yeah, so thanks, Bojan. That's two big questions, and again, I mean, it's to some extent what I'm going to say is kind of stipulative. I mean, I'm asking a lot of the listeners is to accept a certain amount of assumptions, a certain number of assumptions that, well, of course, they could easily refute. But if you accept everything I've said so far, which is a big step, well, I think that it gives it sheds a very simple light on the notion of the rule of recognition. To address your first question, basically, and that's something I've been hinting at a bit earlier, is that the rule of recognition is a self-sufficient concept. That is, that the rule of recognition, if you understand it as the rule that picks out the criteria of legal validity, period, then of course you're going to have debates about does the rule of recognition incorporate constitutional norms? Is the rule of recognition redundant with regard to other norms that bear on some parts of validity, like the rules of change? So if we accept that the rule of recognition is not about conformity, it's not about applicability, but it's about membership, then we can see that the rule of recognition serves a very specific, a very tiny role that is essential. And norms of change, for instance, rules of change, Hartian rules of change, are hotly debated. I mean, all the time you ask whether the legislature could do that. Could it legislate in that fashion? Was it okay for the legislature to do this or that? Or is this contract valid or not? Does if I contract with you that I become your slave, does that respect the statutory norms of contractual change, etc., etc.? This is hotly debated, and judges often have to adjudicate matters that are often sources of big epistemic uncertainties about what the law requires of norm givers, of lawgivers, be it contractual parties or administrative agencies, the legislature, etc., etc. Whereas the rule of recognition, if you follow Hart's framework, the rule of recognition serves a very specific purpose, is to remove uncertainty. So if the rule of recognition and rules of change were confused one another, the rule of recognition could not serve this very specific function. The rule of recognition, it is used by people without even realizing they are abiding by the rule of recognition. That is, that the rule of recognition is used whenever a litigant invokes a statute, invokes a precedent, invokes a custom. Whenever they do that, what they are saying is that here is a legal norm. And as soon as I say, well, it can be traced back to provision X of this statute, which was passed in such and such manner at that date, well, what you're doing is that you're indicated to the judge that what you're doing is invoking a law that exists, that belongs to the legal system. Of course. So, and then the judge will recognize that the norm invoked is legal, that it belongs to the legal system. So if I go in front of the judge and say, hey, in front of a French judge, and I say, well, there is this Serbian law that is applicable, before even reaching the question whether it is applicable or not, it will have to ask whether it is a norm of the French legal system. Of course, it's not the end of the question, but it's part of it. And so, if we define the rule of recognition as bearing only on membership, then it leaves aside all the more contested, the more debated issues regarding conformity to rules of change. So, therefore, and if we agree that assessing whether a norm exists that is belong to the legal system, and assessing whether it conforms to rules of change, well, it entails that the rule of recognition is non-redundant vis-a-vis rules of change, that you cannot explain away rules of recognition by pointing at competence norms. And so that would be my first answer. That is, the rule of recognition serves this very specific tiny rule, which is essential because it allows to have a smooth ascertainment of what norms are legal and what norms aren't. And that's all we need in order to have a minimum standard of epistemic certainty in a legal system. Now to the second question about the inclusive versus exclusive positivism debate. Basically, the exclusive versus inclusive positivism debate was sparked by the attempt to reply to Dworkin's objection, both in taking rights seriously and in Law's Empire, objections by which Dworkin tried to show that moral meritoriousness was an essential condition of the truth of legal propositions. Right? That's the criterion of justification. It's not that it's about norms, but an answer to a legal question is true if and only if it is at least in part morally justified, right? And also it needs to cohere, to fit with past practice. So inclusive and exclusive positivists went into a debate about what the rule of cognition entails. So inclusive positivists usually will use the concept of validity to show that no, sometimes a norm that satisfies all the social criteria of membership, of validity, like they are duly enacted statutes, for instance, they still lack something, and they lack moral meritoriousness, which makes them invalid. So, for instance, like Will Walucho takes the example of the Eighth Amendment of the U.S. Constitution, a norm that provides that unusual or cruel punishments ought to be inflicted upon convicts, is unconstitutional and is invalid. Well, it's quite easy to see, while this example is a non-starter for inclusive legal positivism, that, of course, we could say that moral criteria could be part of, rules of change. That, for instance, norms of change could say the legislature must enact only moral norms. but that would have no bearing on the membership of the norm within the legal system. And therefore, inclusive positivists who says, look, sometimes you have moral criteria of validity are not talking about the same thing than exclusive legal positivists who are saying that the rule of recognition necessarily rests on social fact, that is, picks out criteria of validity that are necessarily social nature, like legislation, precedent, custom, etc. They're just talking past each other. That's what I've been trying to show in a non-published draft, a draft that I'm probably never going to publish, because I feel that the inclusive versus exclusive debate is kind of behind us, and it's kind of outdated now. But still, I still think that there is a kind of a conceptual confusion here. And when you read, for instance, the debate between Ken Hema and Matthew Kramer, it's quite obvious that they are not talking about the same thing. And that at some point, you have a social practice that is law, that rests on social criteria of membership, which is the recognition, what is about. And on the other hand, you have very different kinds of constitutional norms, of rules of change in general, that can very well restrict the content or even the procedure followed by lawmakers and the content of the laws they enact, according to moral criteria of conformity. But that has no bearing on whether the norm belongs or not to the legal system. So that would be, for me, this distinction is a neat way to diffuse this kind of Byzantine debate that has been going on for too long, and actually it's kind of dried up in the last 10 years or so.
Well, I think that we are sliding towards the end of the episode, which I think that maybe for some listeners it would be like, yay, for us it would be like, no. But then I have a last question, and I think that with this last question, we are in some ways circling back to something that we talked about at the beginning, which was basically your views about cluster concepts and why they might be better in some sense for the purposes of what you are doing, and then maybe philosophy of law in general. So the question would be, do you think this kind of like, how do you say this, like modest conceptual analysis, maybe the matrix of Hart, Chiassoni in this sense could be like the way to go in philosophy of law, in opposed to, for example, this very strict or very strong metaphysically driven conceptual analysis or concept construction?
Yeah. Thanks a lot for this question. We can circle back to meta theoretical issues. That's been a long-standing debate in jurisprudence, whether jurisprudence should be in the business of studying the nature of stuff, the nature of things, like nature of law. Of course, we can use the nature of law in a deflationist sense, like what law is. But usually when people talk about the nature of law, like people like Scott Shapiro, for instance, they are talking about some more fundamental stuff, like the essential properties of law, the properties that make law the metaphysical kind it is compared to other metaphysical kinds. And it's true that ever since Mark Greenberg waded into the field with his seminal article, How Facts Make Law, and ever since positivists embraced this kind of strong metaphysical explanations, I mean, Scott Shapiro is again a case in point, but you could have David Plunkett or others. There is this idea that legal philosophers should be in the business of trying to find what is the portion of reality that corresponds to what we call law, right? And I think that is delusional. And of course, I mean, I've written recently a paper on this that is currently under review, and I can't yet say whether it is viable or not. But I still think that, as such, law is a very complex and a very far-reaching social practice or set of social practices. And of course, it's a prime example of social ontology, not the only one, but it is, I mean, it's complex enough and visible enough in terms of how it appears in our daily lives in order to make it part of a rich social ontology. But as soon as you get more metaphysical like that, even when you try to isolate more or less fundamental levels of reality, well, it still appears that law is still on the less fundamental side of the spectrum. And the whole literature nowadays on, grounding on law seems to me, I mean, it's meritorious. I learned a lot reading it, but I still find that trying to ground law or to ground legal validity is as interesting for a metaphysician as trying to ground the fact that my dishwasher is currently broken. I mean, of course, it's interesting, and maybe law is more interesting, but I would say that law is more interesting per se, because it is this kind of social practice that has some peculiarities and some distinctive traits, not as a level of reality. And in methodological terms, it just means that we cannot determine the success or the failure of a philosophy of law by its metaphysical ambitions. That's actually something in his inaugural lecture at Oxford. David Enoch says something that is quite close, actually, when he says that legal philosophy shouldn't be driven by the breaking news from the seminar rooms of metaphysics, and I kind of agree, even if I take it in a different and to some extent more modest direction. But I still think that what you call, yes, modest conceptual analysis. I mean, you talked about Cassoni, because Cassoni, of course, has an interpretation of heart in conceptual analysis that is opposite to this kind of essentialist metaphysical approach. And of course, conceptual analysis is risky, and it sounds futile sometimes. Yes, you take your intuitions, your armchair intuitions, and you try, to develop them into more robust concepts. And it has been contested both on one side of the spectrum by those who do hard metaphysics, and on the other side by those very nice folks who are doing experimental jurisprudence and who are trying to not only, not replace armchair analysis, but supplement it at least with some kind of empirical corroboration or verification. And I think that modest conceptual analysis that is going with our intuitions, our armchair intuitions, but that are still driven to some extent by practice, by practicing law, by studying the way law operates in other legal systems, trying to avoid taking idiosyncratic traits from your own legal systems and generalizing them into, essential properties of law. This kind of reflective equilibrium you make between the concept and the intuitions you have from the daily operations of law. That is something that is more unstable because it's more subject to, incoherence, inconsistencies. You still have to sometimes explain away problematic counterexamples, which make your theory more complex, and sometimes Occam's razor would incline you to just get rid of the theory and starting back anew, etc., etc. So this kind of modest conceptual analysis, which doesn't aim at explaining or finding out the essential properties of stuff, but trying to find what are some distinctive traits of what we call law, I think is still the middle way between, on the one hand, doing only empirical stuff that simplifies a lot the philosophical issues at the background, and on the other side, going deeply metaphysical about law as a more or less fundamental level of reality. So yes, if I could maybe conclude this podcast with something, it would be with a plea for not for excuses, but for a more modest conceptual analysis. I mean, it's given some of the most important books and works in legal philosophy throughout the 20th century. I mean, are we better than Hart, Ross, Kelsen, those guys? I'm not so sure.
Gasp.
A fantastic way to end this conversational part, and I think we had a fantastic discussion. It was most definitely interesting for me, and it will certainly be interesting for the listeners. Starting to notice, but we'll have to think about it, that there is a common thread that I would kind of even now could call a reformist trend. I mean, it's the topics that we enjoy discussing, the topics that are important, the topics that were developed in the 20th century philosophy of law, but approached from some directions that I find very interesting and that open up the field for some social sciences, some natural sciences, some empirical sciences, some other areas and fields in philosophy that I find extremely compelling and interesting. We'll dwell definitely more about that. For now, we learned, I think, a lot about legal validity and Mathieu's ideas about legal validity that he will develop. But we also learned that he published some 40 papers on the topic already.
More or less, yes.
More or less 40 papers as far as I was counting. So he'll be kind enough most definitely to send us the links, because usually, and Jules takes care of that, we usually post some links to the papers and to the books that we discuss with the authors and with the guests on the podcast. So we'll put those links so that the listeners can find them and download them. But for me, it was a fantastic conversation, and I thank you so much for participating in the podcast.
Thank you so much, guys. I had a wonderful time. Wonderful.
The last question that I have, I also enjoyed it extremely much. But the last question that I have would be, do you have a paper titled "Do Grounds Ground the Grounded?" And yes, this is about law somehow.
No, but I know a couple of our colleagues that do have such a paper. I'm not going to name names, but Google is right here.
Thank you very much, Mathieu.
Thank you, Mathieu.
Thank you, guys.
Yes.
Good.